Welcome back to It's Your Law. Mike End and I are talking about some what we think is very frightening legislation that is being put in the legislature already this next week by our new governor. And part of this bill, which is an attack on consumers and victims and very much to benefit corporation defendants, especially insurance companies who need a break, of course. They're making money pretty well right now. But he's even tampered with the rules of evidence, hasn't he?
Yes, he has. There was a U.S. Supreme Court decision back in 1995, I think, that made it more difficult for expert witnesses to be able to testify in cases. And the Wisconsin Supreme Court and the Wisconsin appellate courts, the courts of appeals, have always determined that that law should not apply in Wisconsin because we don't need it. We have an excellent system with expert witnesses. In Wisconsin, it is if the person who calls the expert can show that the expert is a true expert in that field and can show that the testimony of the expert will help the jurors decide the issues of the case, then the expert is allowed to testify. This new law that's being proposed is that the judge can say, I don't think that the basis for your testimony, Mr. Expert, really meets my muster as the judge. I'm not going to allow you to testify. And it's a very stringent rule where the expert witness has to show that there's been testing to support what has happened or what the basis of the testimony will be, even when it's in areas where there cannot be testing. We can't let this patient die in order to prove that doing it the way we've always done it is the better way. Well, even in that setting, the judge has the right under this law, if it passes, to say, I'm sorry, Mr. Expert, you're out of here. And this applies even to criminal cases, so that when the district attorney is prosecuting somebody and he says, here's my DNA evidence, and the judge says, well, I'm not so sure about that DNA evidence. I'm not going to allow this expert to testify. Mr. Defendant, back on the streets. So even the district attorneys in Wisconsin are very unhappy that this provision has been put in the bill. And again, I'm not sure exactly why. Our system has worked perfectly well, but for whatever reason, that's part of the bill as well.
Well, of course, you and I believe in the jury taking 12 unbiased citizens and let them decide the weight of the evidence using their combined experience in life and common sense. This just takes away from the jury the opportunity to even hear it.
That's absolutely right. And that's why the Wisconsin courts have always upheld our system. They've said if a witness is believable and right, then the jury can determine that. If he's not believable and correct, the jury will determine that as well. So this is basically saying we don't trust the jury to assess the credibility and the correctness of expert testimony.
I understand that there also in that bill is some effort to take away punitive damages generally, even in the case of drunk drivers.
That is absolutely correct. In fact, with the drunk driving situation, this punitive damage definition, which is the person has to prove that the wrongdoer intentionally meant to injure a particular person. So I mean, it's almost the criminal standard, or that the wrongdoer knew to a practical certainty that he or she would be injuring the person. Those are things you're never going to be able to prove in a drunken driving case. So that this law will, in essence, say to drunken drivers, don't worry about paying the punitive damages. You don't have to anymore under Wisconsin law if this definition is passed through on this bill.
There is a body of law called products liability where we try to protect the consumer who gets bad medicine, bad tool, bad machine, something that explodes, something that poisons them, something that has something in it that is dangerous. And in the past, we have had a rule that when the victim is injured, the victim can sue anyone in the chain of commerce, from the manufacturer to the packager to the distributor, to put some responsibility, because otherwise people deny knowing where it was made or where it came from. And we know today the greater majority of these products are made in a foreign country that name is Moon during the month of January and changed to Sun by June. And then we can't find them. And so that was the only protection that the consumer had that was injured by a defective product made out of the country. Are they changing that too?
They are absolutely changing that. Part of this proposed law is that if a product comes to the United States from anywhere and it's in a sealed container, that nobody else other than the manufacturer may be found liable for injuries caused by that product. Well, who's the manufacturer? Is it possible to even find a manufacturer, to obtain jurisdiction over the manufacturer? This law says if it comes in a sealed product, you don't have to worry anybody about it. And in fact, the people in Wisconsin, the business people, are going to say, let's send all of our manufacturing work out of country. We'll let China make this stuff.
Well, this is a jobs bill. It's jobs for the Chinese.
That's exactly right. And thinking, oh, we're gaining employment, we're gaining jobs with this is crazy.
Well, apart from the jobs, obviously this legislation has nothing to do with jobs. This has something to do with paying back supporters, protecting the wrongdoers, really protecting insurance companies, and at the cost of the individual citizens who are victims of malpractice, accidents, drunk drivers, bad products, bad medicines, and things like that. It is really something that's a giant setback for the average person who lives in this state.
You know, I should add to the product liability aspects of this bill, another thing that's in here that will be devastating to a lot of people is that there's a 15-year, what they call statute of repose, so that if somebody's injured by a product and it's year 16 when the person's injured, this law says, oh, it has to be within 15 years of the date of manufacture or you're out of luck. So how many pieces of farm equipment,
50 years old,
airplanes that we fly in, all of those things are more than, or many of them are more than 15 years old. If they cause injury, no such recovery for the person who's injured.
Mike End, we're out of time, but we could describe this bill as payback to the money interests at the expense of the citizens. I hope we can fight it, and I congratulate you on the work you're doing.
Thanks, George.
And thank you, ladies and gentlemen.